Okay. So we are going to be talking about planning for a summer trip. So the 5 documents that you should have when you are going on a trip. So my name is Krista Hermance. I'm an estate planning attorney. Our firm is Hermance Law, where we are the estate planning mom and estate planning dad. Um, these are our wonderful attorneys that we have that work at our firm. We are also a very family-oriented firm. And so it's really about just making sure that we have that balance between being able to do the legal side while also being able to be with our families. Okay. Um, we also have offices located throughout Southern California. So Ventura, Westlake Village, Santa Clarita, Calabasas, Irvine, Pasadena. And we also service clients virtually throughout the entire state of California. Um, when we are able to get clients into our office, we do have a few of our offices as kid friendly. So if parents need to bring their kids, they're more than welcome to. Okay, so let's get into it. So when you are planning for a trip, um, and I mean, this is, just from a planning perspective in general, when it comes to estate planning, I think sometimes people kind of get this like anticipation that when they're planning for a trip and they realize, oh, I haven't done any of these estate plans that I've had on my to-do list forever. These are kind of things that I need to get done now. So it really depends on a few questions, right? When you have a trip that's planned. So who's going on the trip? Is it your entire family, as in you, your spouse, your kids, so your immediate family, or is it all of your family, right? Is it a huge family trip? And so it's really kind of determining what specific documents are required then that if parents went on a trip without their kids, maybe there's some specific documents that would be helpful that if something happened and while you were on the trip, to one of your kids where they just had something and they had to go to the emergency room, and you wanted to make sure that whoever was watching your children had the proper authorization to provide that type of medical care that they need. So it's really kind of figuring that out, is who's going on the trip, who or is anybody going to be separated. The next thing is, where are you going? So not really from an estate planning perspective, but just really from a documentation perspective. If you're going international, then passport's going to be required, right? If you have kids that are under 18, or birth certificate sufficient. Are you going without one of the parents? Do you need some type of authorization? So it's really kind of trying to figure out and making sure that you have all of those proper documents in place way before you actually are needing to go, because oftentimes they will take some time to be able to get those documentations that you need. The other one is, when are you leaving? So you want to make sure that you give yourself enough time to get the estate planning documents done before you leave. It's going to be less stressful. As a mom, I know that when I have a trip coming up and we're leaving the next day, I am generally up until the middle of the night packing everything and making sure we have everything we need for the trip. By having all of this stuff done before, which I know it's not always easy to do, but if you can plan for it and try and get it done so that you're not at the last minute literally trying to go find a notary to get something done, or witnesses for something. And I've seen people do this, and I just know the amount of stress it can be prevented if you have that proper planning in place. Okay, one thing I want to mention is, if you have any questions throughout this, please make sure to put that in the chat window, or in the chat, and I will try and get to it when I have a chance. If not, I will absolutely have time at the end to answer questions for you. Okay, so what are the 5 planning documents that I'm going to be going over? Well, it's power of attorney, advanced healthcare directive, HIPAA authorization, revocable living trust, and guardian nominations for minor children. So the first is a power of attorney. So this is basically just a legal document where you give an agent the ability to make financial decisions on your behalf if you are unable to do so. So it allows you to essentially say, if something happened to me and I was unable to make these financial decisions, this is the person that I would want to be able to step into my shoes, to be able to go to the post office, go to the bank, file my tax returns, pay the mortgage, do anything in that aspect that needed to be done if you were unable to do it for some period of time. When you are creating a power of attorney, you have the ability to pick your agent, which is, if anything within estate planning, it's you doing these documents by putting these legal documents in place. These are your wishes, legally documented. Without having these legal documents in place, That's when court intervention is needed. And then you have a judge making a decision for you that you wouldn't necessarily want. And so by doing these documents ahead of time and saying, this is who I would want in this role, you are making that decision. So you get to choose who you want that agent to be. When you create a power of attorney, you're not losing any rights to be able to make decisions for yourself. They can't overrule your decision. It's just the ability for them to be able to assist you if you need it. One of the things that I really like about California is we have the ability to create what's called a springing power of attorney. And so what that means is that when you sign the power of attorney document, it doesn't mean that it's effective immediately, right? It's still in good standing, it will work, but it's only springs into effect if there was some type of incapacitating event. So if you don't have to worry that, when you sign this, your agent's going to automatically have the power to go do any of this stuff. Only if there was some type of event that happened would it then spring into effect. Okay. When you are creating a power of attorney, as well as any of these other documents that I'm going to be going through, it's really important to make sure that you identify backups. So you have one, and then if you can, try and find two alternates. That if something were to happen to that first person, then you would have two backups listed after them. Especially when you are planning for travel and going on vacation. If you list your spouse as your primary agent and your spouse is with you on vacation and you guys are in an accident together and your spouse is the only one that's listed as your agent, then there's nobody that can assist, right? But if you have somebody else that's not traveling with you as a backup, then they would be able to step in and handle anything if it was necessary. Okay. Okay. Next is the Advanced Healthcare Directive. The Advanced Healthcare Directive is a document, it's very similar to the power of attorney, but in this one, you're identifying an agent to be able to make healthcare decisions on your behalf if you are unable to do so. So without this document, your loved ones may be denied access to know what's going on, to be able to make decisions on your behalf. There might be court intervention that's needed. One of the most famous cases when it comes to an advanced healthcare directive is the Terry Schiavo case. Terry Schiavo, if you know the story or you don't know the story, for you remember it, she was 24 years old at the time, living in Florida with her husband, and she had a stroke in her kitchen. She went to the hospital. They worked on her for about 2 weeks, and she never recovered. She was in a persistent vegetative state at that point. Her husband at that time wanted to take her off of life support. Her parents did not. So then what ensued was 15 years of legal battles between her husband and her parents when her parents said, she wouldn't want to be taken off life support. That wasn't what her wishes were. From a religious standpoint, that isn't what she would want. And there was nothing in writing, right? She was young. Of course, when you're young, you don't think you need anything like that. And this is why it's so important in this exact case and for that reason. So 15 years, the legal battles went on. It was very highly publicized. It went to the president of the United States at the time. It went to the Vatican. And then in the end, the husband did end up prevailing. He took her off life support and she passed away shortly thereafter. But it was 15 years, right, that she was kept on life support. And had she had a document that said what she wanted, that would have negated all of that, and made sure that her wishes were very clear. The Advanced Healthcare Directive is also known as a living will. So sometimes people they hear that term, and this is what it's referring to in California. We call it an Advanced Healthcare Directive. When you are creating an advanced healthcare directive, there's also not only the agent that you're choosing, there's also other certain end of life decisions that you'll want to indicate in there. So do you want burial? Do you want to be cremated? Do you want to do any type of organ donation for transplant purposes or medical research? Or none at all, right? Making that very clear on there. Do you want prolonged life support with extreme measures, or would you want to be taken off life support? Another thing that I talk about clients, because we help a lot of clients that are young, young parents that have young kids. And we put some time frames on there that they don't want to be taken off life support for so long, really kind of just kind of see what's going on, to give them a chance, to allow family to be with them. And then, after a certain period, then they would be taken off. So you really have the ability to put what your instructions are and what your wishes are in this legal document. Um, One other thing I will mention is when you identify this agent that you want to be your agent for your decisions that you're making, or that they would be making on your behalf, is you want to make sure that you choose one primary and then two backups if you can. So have those backups listed, but you want to make sure that the person that you're choosing is going to actually be able to make the decision for you, right? It's going to be a very emotional situation. I work with clients all the time, and that's something that we really kind of go through, is figuring out and saying who would be able to make that decision in my family. And a lot of times, their first instinct isn't the person that they would want, because they don't think that they could make that decision for them, in that situation with that high stress, as well as just the emotional aspect. So they end up, really having to think about that, and choose somebody that they think could make the decision for them. Okay. Again, if you're just joining us, please make sure to put any comments or questions in the chat, and I will try to get to those. And we're going to go on to the next one here. So the next document is a will, and this is probably the most common estate planning documents that most people know of about when they hear about estate planning. It's in referring to a will. So what is a will? Well, it's a legal document where you give specific instructions to be carried out after you pass away. So in your will, you can say how you want your stuff distributed, right? How do you want your money going to somebody, property going to somebody? In your will, you can also nominate guardians for your minor children. So that's anyone under the age of 18 that you have as a child. You want to make sure that you have guardians nominated for them. We'll talk more about it a little bit, but in your will is one place for you to be able to nominate those guardians. If you have minor children, and they are getting money, depending on how the will is stated, they could get money when they turn 18, or it could create some type of trust that's created as part of the will, to be able to kind of set up how you would want your kids to receive money. This isn't generally what I would recommend, is if you had minor children and getting money for them, because it goes through that probate process. So when a will is filed, when somebody passes away and a will is filed with the probate court, it is made public, right? It's a public record. You see it all the time on like TMZ. When a celebrity passes away, they're going to go pull the court documents and find out, who in the family is getting what, or if they didn't have a will, how is it passing through intestate law? And so that's things that are reported on, because anybody can pull the documents. They're court records. They're public. In California, if somebody passes away and they don't have a will, their estate passes according to California law, which is intestate law. I kind of just mentioned that. And it's basically just this distribution of how California says this is how your stuff is distributed. It may not be necessarily what you want. And that's why having a will or some other planning documents are so important, because again, it's your wishes, right? This is your opportunity to legally say, something happens, how do you want your stuff distributed? And this is one thing I think a lot of people just don't really understand, is you have the ability to do all of this now, right? You have the ability to say how you want stuff to happen or be distributed now, because if something were to happen and you had no instructions, then you have no say, right? It just goes according to California law. And it's so important to remember that. So one of the biggest myths that I hear from people is, oh, I have a will, so I don't need to worry about it. My family's good. It's going to avoid probate. That is not true. Okay. A will alone does not avoid probate court, because what it's doing is it's really guaranteeing probate court, because it's telling the court, here's how I want my stuff distributed, right? According to my will. And so it's telling the court, so the stuff has to go through the court to be able to get to your beneficiaries according to your will. So again, having a will does not avoid probate court. It's not the only planning document. And for most people, especially in California, it's not the document that's going to really dictate your estate plan, right? There's other stuff, and I'm going to get to that one now. Okay. So a revocable living trust, also known as a trust, as some people hear it, is really kind of the essential planning document especially in California, when it comes to estate planning. So what is a trust? Well, it's basically just an agreement between you, as the grantor, which is the creator of the trust. They put specific instructions in writing in this legal agreement to the trustee, which is the person who agrees to hold legal title to all of the assets in the trust. And they do this for the benefit of the beneficiaries. Okay, so three kind of big terms I just threw at you: grantor, trustee, beneficiary. So while you are alive and you have this revocable living trust, you are all three of these roles. Okay. It's your trust. You created it. You're putting all of your stuff into your trust. So you're in control as the trustee, you're in charge of it. And it's also for your benefit, right? You're not giving up any control or access to your stuff in your revocable living trust. It's only if something happens to you that within your trust, you have all of these kind of backups and beneficiaries that people would be able to then follow your instructions on how to deliver the assets to your beneficiaries that you have listed in your trust according to your wishes. Generally, when you have a trust, there's no court involvement, right? And so, like in the previous one where you were talking about a will, the will has to go through probate court to have everything distributed to the beneficiaries. Well, when you have a trust, it avoids probate court, right? If it's fully funded, all your assets are in the trust, there's nothing that has to pass through probate court. Probate court in California is very expensive. It takes a really long time and it's public. And just to give you an idea of how expensive probate court actually is, let's say you have an estate worth like $500,000. So maybe like a house worth 490 and $10,000 in checking and savings accounts. And you have all of these assets in your name individually. So for that $500,000 size estate to go, and it's not the amount in your mortgage or the amount of equity you have, it's the fair market value of the house. Okay. So $500,000 to go through probate court is going to cost in statutory fees. So it's set by the state of California, the fees that it costs. It's $26,000 for the personal representative and the attorney for that to go. So that's coming right out of the estate. And then you have costs on top of that for filing the petition, the closing petition, publication, bond fees, probate referee. So all of these additional costs add up. It's almost $30,000 for a $500,000 estate. And that just goes up depending on the value of the estate. That can be avoided by having a trust because a trust avoids probate court and it keeps it private. So it keeps the cost down, keeps it private, and it also makes it go a lot quicker. So probate court right now, we're looking at times at the minimum, which it really depends on the court. Some courts have a lot more cases. So we're looking at 9 months to 2 years for a probate proceeding. And that's uncontested, meaning that the beneficiaries are getting along, that nobody's, questioning capacity or anything like that, because that adds a whole nother side to it, right? If somebody's contesting some aspect of a will, that's going to add more money to legal fees. And it's going to take more time. So those are all kind of things to consider. Um, One of the biggest myths that I hear about trust is that trusts are just for the wealthy people, right? Somebody will say, I'm not Bill Gates level. I don't need a trust. And that's just not true, right? A trust is really for any family that wants to put a plan in place to make sure that their family is going to be protected, right? For all the reasons that I just said, saving money, keeping it private, making sure the stuff goes the way that you want it to go. That's all stuff that can be done with a trust. And you don't need to have a lot of money for the trust to be able to make sure that that's going to happen. Even with that example I gave with the $500,000 estate, that's a perfect example of somebody having a trust, right? Because then you have a house and you put that in your trust, and then that would avoid probate court. And then it's distributed the personal way, the non-public way, according to the terms of the trust. So, I mean, that's very common. Somebody to have a home, some checking accounts, life insurance, retirement, they put all of that in the trust. You don't have to be wealthy, be at a Bill Gates level or somewhere up there to have a trust. Okay, so some of the benefits of a trust are setting up sub-trusts for your kids. So if you have minor children or kids maybe that are under a certain age that you think, if they came into some money, would it really be beneficial to them, or maybe they might not make the right decisions with it. So you can set up sub-trusts to be distributed to your kids at 25, 30, 35. Whereas if they went to them through the court system and there was nothing in them that set up a trust or something, they would get all of that money when they turned 18. And a lot of times if an 18-year-old comes into money, they're probably not going to be mature enough to make the right financial decisions to make sure that money is going to be there to kind of grow with them. And a trust allows you to be able to do that. A trust will also allow you to have um, certain aspects of it that will protect your children's inheritance from predators, creditors, and divorce. I see so many things in courts, the court system, where clients will come to us and they their parent passed away and they were remarried, and then everything went to the new spouse, and then they got nothing. And so we have ways in creating a trust to make sure that that doesn't happen to your kids, right? um, when you have a trust, you get to choose the trustee to be able to manage the finances on behalf of your kids. It could be a guardian. So if you have minor kids, you could say, I want the guardian to be the same person as the person who's managing the trust as the backup, but it doesn't have to be. I like it that, if you have minor children, you could say, well, I would want, maybe my brother to be the trustee because he's really great with money. He's the financial advisor, he's organized, he's perfect, but he's horrible with my kids, you know, and I would want my sister to be the guardians for my kids, but she's horrible with money. So then you have kind of a check and a balance where sister handles the kids as guardians, brother handles the money aspect, and then they can work together to make sure the kids are being cared for. It doesn't have to be that way. This is your choice. So you get to choose how you want to have it set up. Or if you have adult children, you can absolutely have your kids be the trustee of your trust. That's very common with a lot of our older clients where they have adult kids. Their kids are, they want them involved in all aspects of their life and being able to be there to care for them, and they want them to take over if something were to happen. So absolutely, you can have your kids. Like I said, having a trust just really just keeps it private, right? So no court involvement generally, which means less money. That $30,000 in fees that's going to be paid from having to go through probate in the example that I gave. One of the really great benefits of having a trust that I like, especially for parents with minor kids, is that when you have a trust, you can list your trust as the beneficiary on your life insurance policy so that if you do have minor children, that money doesn't go to them if something were to happen to you. So, I see this a lot with couples that'll come in. They have each other listed as primary beneficiaries, and then they'll have their minor kids listed as backups their um, on their life insurance. And maybe they have one kid listed as a backup, and they've had a few more kids but never updated it. It's generally the way that I see it. And so a lot of times people don't really think of the impact that could have. But if something were to happen to both parents, and then all of that life insurance proceeds went to the minor kids, they can't receive that money. They're under 18 if they're minors. They can't receive it. So it has to go through a court guardianship where someone would be assigned to manage it on their behalf. And then they would get all of it when they turn 18. And a lot of times I think parents don't really understand that when they're looking at life insurance or retirement, any of those benefits, they would want to make sure that that money is protected for their kids. Of course they want their kids to get it, but how are they going to get it? And so by having a trust, if you say in your trust, well, I would want my kids to receive money at 25, 30, 35, so you list your spouse as your primary beneficiary, and then you list the trust as the backup. Then if something happens to both spouses, then the money goes to the trust to be distributed at the ages you set for the benefit of your kids, right? So it's really just having these different options on how you want to make sure that if something happened. I know it's hard to think about. And that's one of the biggest reasons I see people putting it off is they don't want to think about it. But you have so much more flexibility and control by doing this planning now, right? Because if something happened, and that's where we call crisis planning, is trying to figure out then what can we do. And a lot of times it's not what somebody would want. Okay, so real quick, let's talk about guardian nominations. So again, I said you can do guardian nominations in the will. We do it as another aspect where we do a separate document for long-term guardians as well as short-term guardians. A lot of times people don't think about that. So you just want to make sure that when you're choosing guardians, you choose somebody that has the same parenting style, will provide the same values, the best education, love, and support for your kids. Okay. You also want to make sure you have alternates listed for guardian nomination. So having one and then, two backups if you can. You have the ability to document your wishes very specifically. So maybe if you have, your primary guardian jointly, where it's like your sister and your brother-in-law, but you wouldn't want your brother-in-law to raise your kids by himself. So you put, sister and brother-in-law, sister okay alone, but brother-in-law is not okay alone. So then it would go to the next person. You also want to make sure that you can choose anyone for guardians. It doesn't have to just be family. It can be friends, close friends. You want to choose somebody that your kids know that they feel comfortable with. The biggest thing to remember with guardian nomination is without having some legal document that says what you would want, a judge has no idea. what your wishes would be. They don't know you, they don't know your family, they don't know the situation, and they're making this determination, not having any input from you. And that's why the guardian nomination is so important, because it gives you that voice. Okay. Um, for attending, I want to make sure that you guys get my travel preparation checklist. I am going to post the link for that here for you, so you can make sure to download that. I'm going to put that in the comments now. Um, if you need help avoiding probate, getting your summer planning done, and making sure that all your wishes are legally documented, please schedule a free 30-minute phone consultation. You can go to our website to get that scheduled. I think I need some water. Um, and I will put the link there to make sure that you can get that scheduled, to just kind of figure out what the process is. You know, the biggest thing when it comes to planning, especially if you have a summer trip coming up, is you want to make sure you can get it done in time. Our general process takes about a month to do. We can do it sooner. I see that happen, where, if it's a trip that's coming up, if we can plan accordingly and get stuff done, we will try and accommodate it. But you want to make sure you give yourself enough time. And so our process generally takes about a month, from the time that we have the first meeting until the time that the documents are signed, just so you kind of have that idea. If you have any questions, please put those in the chat. Um, I will be sure to try and get to those. I do want to be mindful of your time, in joining me today. And I do want to say thank you, for taking the time to watch this. I hope that it was helpful and informative, and just really kind of gave you some ideas to think about, as you start planning for summer and any trips that you have. Do you have the proper legal documents in place? So make sure, if you have any questions, to go ahead and put those in the chat. One thing that I kind of thought about, like literally 3 minutes before I was logging in to do this, was just some of the kind of things I've seen in probate court that people, I feel like, kind of did last minute. And I'll share those, a couple of things with you, just to kind of say, like, don't don't do this if this is what you're kind of thinking of. This is, I've seen it backfire. Um, um, so one of them is, where, like, parents be getting ready to go on a trip, and I see this all the time. They say, "Oh, we need something, right? We need something in writing if we're leaving our kids." And the best advice that I can say there is, write it on a piece of paper in your own handwriting, sign it and date it, and make sure that you give it to whoever's watching the kids. There's ways that we do it that I think are just to prove the legality if it ever came up, to show. But that's one thing that I think, having it in your own handwriting is very important. Your signature. Where I've seen issues is, especially when it pertains to a will. Somebody will go online, they'll create a will really quick, and it'll be all printed in the, just the printout from the website, and then they just sign it. Well, one, it's not a valid will because it's not witnessed. And if for it to be what we call a holographic will, it would need to actually be in their handwriting. And so it wouldn't be a valid will. It wouldn't be accepted. I've also seen people where they'll do like an online will and they'll sign it and then they'll go get it notarized. Well, that's not a valid will, because the will in California, the requirements require two witnesses. And so the notary can act as one witness, but then you would need an additional witness. And so those are just some kind of last minute things that I've seen that I kind of just wanted you to be aware of, right? Things that, people had the intention, they just didn't do it properly. And so that's why it's really important to make sure that you are getting it done properly, that it's, if it ever came about, that it would be valid, right? Because that's what your intentions are. Um, would like to show this to my niece with kids. Will you have another webinar? I do workshops once a month. I do these lunchtime webinars. I call them lunch and learns on a monthly basis. Every month is a different topic. This one will be recorded, and so you should get the recording in our email that's going to be going out, as well as I think a recap is going to be sent to you. So you can forward that to your niece, or share it with anybody if you have anybody else that you think would benefit from this. But if you are on our email list now, you should get emails from us with information about when our next either workshop is or very similar webinar to this. Okay. Okay. Thank you so much for joining me today. I hope you guys have a wonderful day.